The next case is State of Ohio with Thomas Williams. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, you don't know how long you'd like to reserve for rebuttal?
3 minutes, Your Honor.
Thank you. I'll be keeping track of it up here. I'll try to let you know when you're about a minute left in your time.
Excellent. Thank you.
No problem. The arguments are being recorded. When you come to the podium, please make sure to introduce yourself. Make sure that you speak up so we can hear you as we're recording, and that you stay behind the podium, because if you move, then we kind of lose you off the recording, so we appreciate that. Do not use the name of any children, minor, or victim during your argument. Refer to them by initials or terms like the child or the victim, if that is relevant in this particular case. The judges have read your brief. Are you ready to proceed whenever you are?
Thank you. Good morning, Your Honors. Attorney Ryan Haddox here on behalf of appellant Thomas Williams. May it please the court. Appellant's here on 2 assignments of error stemming from an OBI case starting in late 2022. The first assignment of error that's presented before the court is that the trial court abused its discretion in denying the appellant's then motion for leave to file a motion to suppress, or his earlier motion of motion for extension of time for pretrial motions. And the second issue, somewhat related to that issue, is that the trial court erred in finding that the Intoxilizer 8000 records were not discoverable evidence under Criminal Rule 16. Now, in addressing the first assignment of error here, when addressing these issues for the extension of time, we're looking at Criminal Rule 12. Now, Criminal Rule 12 clearly governs the filing of motions to suppress or pretrial motions, and they must be filed, as well known, 35 days following the arraignment. The arraignment in this matter occurred on December 22nd, leaving that 35-day window to January 26th. Now, the initial motion for extension of time was filed on January 31st, a few days following that 35-day period. Now, once an extension is requested after that 35-day period, we're firmly under Criminal Rule 12H, which governs these post-time frame applications for the extension of time. Now, it's clear under the jurisprudence of this court that whenever such a motion is being presented to a lower court, that the extension of time can only be granted for a good cause shown. Now, here, good cause was indeed shown.
Well, if there were some still outstanding discovery questions, why wouldn't there have been a motion for leave filed within the initial period?
So I don't have knowledge of what was going on at the trial counsel's goings at that time. I do know on January 31st, a supplemental motion was filed with the court requesting this additional Intoxilizer information that had not been received. This information was specifically requested in the initial discovery request, and the link to the Intoxilizer was not made available to trial counsel until the following day, February 1st, still after the initial date for filing of the motion to suppress.
Was there a trial date already set on January 31st when the motion was filed?
No, there was not at that time, only a future pretrial date set for March. Trial date was not set until March, late March for July of that year.
Was the only reason for good cause shown in the case that all discovery had not been completed at that point?
That was a key component of it, certainly. But additionally, there were ongoing resolution discussions with the prosecutor and trial counsel at that time, as well as important constitutional issues related to the suppression issues. And to that end, we rely heavily on a decision from this court recently in State v. Minor, representation 2022 Ohio 327. It was a case decided here in 2021. It dealt with a very similar set of facts coming from an OBI case. Discovery had not been fully completed, and a request for an extension of time was denied. But good cause was found in that discovery had not been completed by the time of the request for the extension of the filing. There were important constitutional issues at play, and there were ongoing discussions to resolve the case at that time.
In that case, was the request for an extension made within the first 35 days?
No, it was not. It was made afterward, similar to this case. And in that case, good cause was shown, and we think similarly here, discovery had not been completed at that time. There were ongoing discussions that following pretrial was set for that February 2nd date, so very close to that window for the 35-day and very near when the extension was requested.
So what's potentially distinguishable in this case is that what you claim is discovery was also public record.
So yeah, and that ties into their second assignment of error here. So while the intoxicator records are maintained by the Ohio Department of Health and are available on their website, the Supreme Court of Ohio has found that there's an affirmative duty by the prosecution to supply these records, specifically in Cincinnati versus Ilg, the appropriate citation there, 141 Ohio State 3rd 22. In that case, it dealt with Intoxilizer 8000 records. The defense in that case had sent a request in their demand for discovery, sent in a follow-up request and subpoenaed the Ohio Department of Health for the records. They were not provided, and eventually sanctions were imposed by the lower court for the failure to provide. It was found that those records, there's an affirmative duty to provide those records when requested. I mean, that extends back to longstanding Supreme Court jurisprudence, like Brady v. Maryland, where there is an affirmative duty to provide potentially exculpatory evidence with or without a request by the accused. So similarly here, there was a request by the accused specifically for these intoxilizer records. They were not provided. In fact, the link for the availability of them online was only sent to trial counsel on February 1st, which was following the request for the reiteration of his request for the records and after his request for the extension of time in order to put together the motion to suppress on that issue. Those records were eventually provided or reviewed by trial counsel, and there were issues with the certification report that would have made its way into a motion to suppress on the issue. At any rate, the trial court should have found that there was an affirmative duty by the state to provide those records. And the fact that the state failed to do those and merely just pointed to a link where the defense could have potentially found them is not really complying with their duty under Criminal Rule 16.
Isn't that how most discovery is done? You're given a link and then you click on it.
Well, I think there's
You're looking for.
So yeah, I mean, certainly there's a lot of link sharing in our online world, but I do think there's a marked difference between a directly link to a video file that when you click it, it opens the video that you're looking for, versus a link to a website where you have to feather through information to find the specific device that you're looking for and the specific records. I think it's more prone to confusion or difficulty by the defense, and it places a burden that shouldn't be placed on the defense to find the appropriate records when they could and should be shared by the prosecution.
I have a little bit of confusion regarding when the state provided the link. And perhaps I'm reading the trial court's entry wrong, but it says defendant cites no law for the proposition that the prosecutor's actions here, i.e. alerting and directing defendant on January 5th to public access records. But you're indicating to us that the link was not provided until February 1st, so I have a little bit of confusion on that particular issue.
Yeah, I'm basing that date off of the affidavit of trial counsel. I believe it's at page 17, where he notes that on that February 1st date is when he was first advised.
But do we have the state's initial response to discovery from January 5th? Do we have that in this record?
I believe it's in the record, and I don't think the link was included at that time to the corporate records, from my understanding. I
Okay.
didn't personally review the initial discovery of this case, nor was I involved at that time. So I can't speak to specifics there, but based on my understanding of the record and the affidavit provided by trial counsel, it would appear that he first became aware on February 1st that he was going to have to independently pull and find those records as opposed to that being affirmatively provided by the state.
Okay, because the trial court's entry says defendant concedes that he did receive the link on January 5th. I mean, that could be incorrect, but I'm reading from the trial court's entry, so that's what I'm asking about.
Yeah, I'm familiar with that entry from the trial court. Like I said, basing my statement exclusively off of the affidavit filled out and sworn to by trial counsel that he wasn't aware until February 1st. I have to be in full disclosure, wasn't involved in the case at that time. I really can't say if it was affirmative At any rate, trial counsel did eventually reiterate his request for the report, although after the 35-day period for filing those motions. It's our belief that there was indeed good cause shown, that the state skirted its affirmative duty by simply pointing to where the information could be found, as opposed to clearly providing it as requested by trial counsel well ahead of the schedule of the initial December 22nd filing in his demand for discovery. And as such, there was good cause shown, and accordingly, the first assignment of error should be overturned, allowing for the extension of time to be filed to give trial counsel the opportunity to present the real and serious constitutional issues at a motion to suppress hearing. There was no trial dates at that time. In fact, the case was resolved months later ahead of the trial set even further out. There was no compelling reason by the trial court to deny the extension of time given those circumstances. And additionally to that end, is the second assignment of error that should also be reversed, in that there was an affirmative duty by the state under Criminal Rule 16 to provide these intoxilizer records, and they failed to do so. This was discoverable information and should have been provided timely. Thank you.
Thank you. You'll have your full rebuttal time.
Thank you.
Good morning. May it please the court, my name is Robert Campbell. I'm Assistant Prosecuting Attorney for the City of Medina, here on behalf of the state of Ohio. Your Honors, I guess to help, I hope, set some parameters on this or context. Mr. Williams was arrested for OBI and arraigned in December of 2022. On January 5th of 2023, the state of Ohio emailed to defense counsel a response to the request for discovery. Included in that was a police report, breath testing device information as far as the test result, and the identifying information on the machine that it was taken. And the cover sheet that comes with all of our recovery or discovery requests indicates, note, records for the Intoxilizer 8000, which this was, are available online. Between that period in time and the day the motions to suppress were due, there was no extension of time requested as a result of saying, look, I can't find these Intoxilizer records. That was never brought up until after the expiration of the 35 days. In fact, when the link was provided, and I believe that question was asked, we formally sent the actual link that you could just click on through your email and go to the site on February 1st, which was the result of a February 1st supplemental demand for discovery. So the specific discovery-related demand for that information, suggesting that counsel was not able to get it on their own, was filed February 1st, which was after the 35 days. Additionally,
Excuse me, when you direct them, when you provide the link, does it just take you to the Ohio Department of Health website, or does it actually
no.
or so does it take you to the exact result?
a little bit in between. It takes you to a portion of the Ohio Department of Health website dedicated to these results. So it's not like it goes to just welcome to the Ohio Department of Health. You go right to Intoxilizer 8000 page. At that point, you need two pieces of information to get everything. You need the defendant's name, the person who was tested's name, and the date of the test. You don't have to search, you type in the date, you type in the name, and boom, everything comes up on your computer.
So pretty clear prompt to type in and say, name of defendant and date is on
Correct.
there, that when you look at it, pretty straightforward.
Correct, it's surprisingly user-friendly.
And the state's position is that information that comes up that's specific to the test is wholly a complete response to the discovery request
Yes.
by the defendant.
Yes, that provides everything that we get if we directly asked for it from the Ohio Department of Health.
Well, let me ask you this, since I'm all about the trial court's language. The trial court said that even if the defendant had regarded that link on alert that came to him on January 5th, see if he went there, and found that online data to be inadequate, ILG supported subpoenaing the data directly from the Ohio Department of Health.
Mhm.
Is it the defendant's burden to subpoena the Ohio Department of Health for the discovery that it's requesting from the state? I mean, it
Is
says subpoenaing, so.
Yeah, I think I understand the question. I think you're asking if, and if I'm wrong, please correct me, if the defendant has a duty to subpoena in place of discovery. I would not argue that, okay? But I would suggest that ILG is, I mean, we have to read ILG in the context of technology in 2014 versus 2024. In 2014, a defendant couldn't go to a public website and get that information from themselves. It wasn't available to them. They could have done a public records request and all that. But again, and I'm not suggesting that's a substitution for discovery either, but that was a time when ILG was decided, when that information was peculiarly, I apologize, in control of the state of Ohio. So of course that would have to come through, or should come through a discovery request. But this isn't any different. This isn't peculiarly in control of the state of Ohio anymore, when any individual anywhere in the world can go to it and find it with a simple click. It's like asking the state to provide weather information for the date of the offense in discovery. Well, you can find it just the same as I can. So that was the situation with the information that the defendant claims to have been waiting for.
I have another question.
Yes.
Where does the discovery line, so you know, you when you look these up, you see the, if there's been an update and, you know, there's some history to these machines.
Mm-hmm.
Where's the line where the prosecutor has an onus to affirmatively provide a defendant with the information? Do you believe it's discoverable, every bit of information about the machine, or is there just that on the date of the test, if it was certified? I mean,
Well, I guess that depends on what the defendant's looking for. I would think what would be relevant here, what would be the test result itself, and its calibration and updating of all that, the dry gas control and all that kind of thing that's done once every year. And on that link that you get every one of those recertifications to the beginning of time for that machine. So I'm not sure if I'm
so you think
completely
that,
understanding your question.
So the full history of the machine is discoverable and potentially exculpatory?
No, I don't think the full history of the machine is exculpatory. The machine could potentially not have been working, you know, on July of 2020 and working just fine because it was fixed or something was changed in November of 2022. So that's where I think that line would be drawn. But importantly, all of this information was available all through the first 35 days. But if there were problems, it could have been brought to the court's attention within that first 35 days as well. Demand for discovery to sort that out, or a motion to compel discovery to sort that out, a motion to extend the time. The municipal court freely extends the time if asked ahead of time. It's when we've missed that deadline is where we run into problems. And there's one other thing that I'd like to point out to the court that I apologize I did not raise in my brief, because quite frankly it occurred to me this morning when I was reviewing these things. In this case, the defendant entered a plea of no contest to a charge of 4511-19A1A, which is driving under the influence of alcohol. The 4511A1, I believe it was D subsection, which was the positive breath test, was dismissed and exchanged for the plea. So defendant's plea here and the charge that he was convicted of had absolutely nothing to do with the breath test. The breath test in that matter would not have been relevant if it was the A1A charge was tried alone, unless there was expert testimony and so forth. So the state of Ohio believes that all of these issues have been waived. Again, it occurred to me this morning, so I did not brief it, but I think that is an important thing to know. And if there are no other questions, I am done.
Thank you.
Thank you very much.
Thank you, Your Honors, just quickly. As it pertains to our second assignment of error here, the state in both its brief and oral arguments today seem kind of hinging their argument on the fact that the intoxilizer information was not purely or exclusively in their control and that it could have been accessed through other means. Now, I don't believe that Criminal Rule 16 contemplates sharing evidence that is only exclusively in the control of the state of Ohio. The fact that defense could have or potentially should have retrieved that information independently doesn't relieve their affirmative duty to provide that information. A public records request is not a replacement for Criminal Rule 16 or the discovery process. Criminal Rule 16 very clearly governs these sort of procedures and should be paramount even when a public records request is available. As to that last point concerning the resolution of the case, I think it's tough to speculate on how the case would have resolved had there been the ability to file a motion to suppress in this matter. It's unclear what the resolution would have been. To make speculations based on how the case did resolve under these circumstances, sort of a moot point for this argument. If there are no other questions.
Thank you.
Thank you, Your Honors.
And thank you both for your presentation today. The court will take the matter under advisement and issue a decision in due course. When that decision is out, the clerk will mail a copy to you and also be released on the Ohio Supreme Court website. Thank you both for your presentation again.
Thank you, Your Honors.
Thank you.